Ladies and gentlemen and ladies and gents, we're gonna do our little courtroom conversation. Y'all don't mind? Gonna have the little music playing in the background as if it was playing through the audio surround system in the courtroom. And we're gonna ask a couple of questions. You know how you go to these courts and y'all are answering their questions? Stop answering their questions. Stop answering their stupid questions. You're not there to testify. Your Honor, I got a question. That's all you got to say. Your Honor, I got a question. I need you to ask the opposing party, whether they be plaintiff or anything else, what is the pledge collateral in this particular transaction that's being discussed today? Now, if they pretend they don't know what the pledge collateral is, then the one thing you say, excuse me, let the record reflect that the opposing party has made a claim that they are not familiar with pledge collateral and have no idea what it means. They will say, no, we didn't say that, Your Honor. I'm sorry, Your Honor, was not the question to them, what is the pledge collateral associated with this transaction? And did they provide an answer to the question? The answer is no. They asked a question, which means they do not know what I'm talking about. And I just said, let the record reflect that they have pled ignorance. Doesn't matter what question they ask. Doesn't matter how they ask it. Well, what are you trying to say? Are you talking about A? Are you talking about one? Are you talking about zebras? Are you talking about cats? Are you talking about... Doesn't matter what they say. If they don't answer the question, then that means they're saying they don't know what you're talking about. Okay? And if they don't know what pledge collateral is, that means that they are not handling their fiduciary duties as required by law, because they are the custodians of the pledge collateral. They know about the borrower in custody agreement. They must understand what pledge collateral is because they've used the discount window. Okay? Your Honor, thank you. They've just provided material evidence that is exculpatory, since they are claiming that there is an outstanding balance and that they are the creditor, and they don't understand what pledge collateral is, but it is necessary to have been at issue in this instant matter. I move for immediate dismissal. On what grounds? I'm sorry, you misunderstood what I just said. They are the custodians of the record. They are supposed to know what pledge collateral is. The very fact that they said they didn't know what pledge collateral is, then they are denying me my right to get a listing of all the pledge collaterals in the matter. This state has adopted the Uniform Commercial Code, specifically Article 9 dealing with securities and pledge collateral. And Section 210 says I have the right to ask that question. And they have just denied me that right, and I've asked it previously, and they denied me that right. And there are penalties for when they deny a person the right to know the collateral that has been pledged. That's it, people. That's how you start putting a stop to all of this stupidity that's back and forth. Hey, tell them about how much you love it. Making you what?
Sometimes I feel good.
Hey, y'all hear what she said? She feels good. And she feels used. Ladies and gentlemen, that's Miss Keys. And I'm certain that many of y'all remember when that song first came out. Well, anyway, that's what we're going to suggest you guys do. Go back over what I just said. Understand the premise of what's being said. They are the pledgers of the collateral. No, they are not the pledgers of the collateral. You are the pledger of the collateral. You have pledged your collateral. Now pay attention, since you have a right to know the specific different collaterals that are involved in a transaction, a list of them, they have to list the promissory note. Your Honor, they want the house. They can have the house as soon as they surrender the other collateral. Your Honor, but no, sorry, Your Honor, they only put in a petition to foreclose on the home. They didn't foreclose on the other collateral, so they've just forfeited their right to that. So they can have the home, but I need an order from this court demanding that they provide me my property. What, are you going to say, Your Honor, that I am not the pledger of the collateral? They can't say that I'm not. They just admitted they didn't know what I meant by pledge collateral. But I know what I meant by pledge collateral, and the law knows what I mean by pledge collateral. And guess what, Your Honor? You know what I mean by pledge collateral. So I need an order for them to return my property, because it's a property right, and that's a constitutional issue, and you must address that issue in your constitutional judicial capacity as a matter of law. Ladies and gentlemen, the law is not complicated. Your situation with foreclosure is not complicated. It's just that you're letting them change the subject. And so long as you let them change the subject, you'll be sitting up there fighting. Because every time you accomplish one thing, they then change the script on you so that you're trying to accomplish something else other than the true issue. Let them have the house. Get your collateral. Many of you have let them foreclose on you, and you haven't gone after the pledge collateral. People, take them to court for your pledge collateral. Get them to document on the record that there was no pledge collateral so that you can get them for perjury. If they used the discount window, there was pledge collateral. And it wasn't just your home. Now remember, get a listing of the pledge collateral. Go back, read UCC, Article 9, Section 210, and read it for your state. Sorry, this is a allergy season for me, and I'm out here in this weather, and no cold or anything. It's just this stupid pollen. We just had this rain. Now look, y'all, we got over 5 inches of rain. Okay, yesterday, 12-hour period. That's not supposed to happen. Normally we get like a quarter inch of rain, especially in 12 hours. But to get 5 inches of rain, it rained all night. From 2 o'clock to, 9 o'clock in the morning? You know, it wasn't even 12 hours. I just realized that. I mean, it was drizzling until after 2 o'clock, but it wasn't even 12 hours. Now that's interesting, because that doesn't happen like that out here. But we needed the rain, because we haven't had any rain since April. Okay? Because it doesn't rain like it's supposed to, because they keep messing with the stupid weather pattern. Look, go back over this. Understand the issue is your pledge collateral. Those of you who've been foreclosed on, go after your pledge collateral. All right, I'll try to put together a petition asking for the surrender of your pledge collateral and getting them for fraud. Because fraud, there's no statute of limitations. So even if it was 30 years ago, the fact that there were two collaterals, they were supposed to liquidate the other collateral and give you the balance. They never notified you. That's how you go after them. Go get your money. Okay? Go get your money. Because it's your money. It ain't theirs. Go and get your money. The pledge collateral belongs to you. Doesn't belong to them. All right, hey, I gotta go. It's been an interesting morning, a 2-video morning. Now I'm about to go and relax. Goodbye. Uh-oh.